So who should you choose to be the executor of will? All the children? Only one of them? Close friend, relative? What's the? Is there a golden rule?
Yeah. Well, I suppose it might be worthwhile just putting up. Can I use the whiteboard?
Yeah, sure.
Just quickly, because this is a scenario that we'll talk about. This is George, and what happens to George, of course, is he's lost a bit of weight.
All again.
He's got a nice little plot with a flower. Yeah. And then, of course, if anything happens to George, his estate goes to his lovely wife. But of course the question is, what happens if his lovely wife is not around at the time because she was travelling in the same car with George? What did they say? My grandfather died in his sleep, which was pretty crook for the people in the bus he was driving at the time. That now we've got all these other people who are now entitled to George's estate. So when you say who should be your executor, well, normally what people do is they name their spouse as the executor, and that's fine. So George will name this is George as the executor initially. But any decent will has to provide for the prospect that your wife will not be around at the time. And that means you've got to provide for an alternate situation. And that's when things get interesting. So the question is, who would you choose as your executor? Initially your spouse. But you then have to have a second choice, and maybe even a third choice, in case your spouse is not around.
That's added in the will.
That's right.
Okay.
Your second choice depends very much on your particular family issues. An executor needs to be someone who's got, doesn't have to be someone who's very learned. You don't expect executors to understand all the law about wills or anything like that. Executors go to solicitors. That's what solicitors are for. They help them handle the probate, handle all the formalities, etc. What executors have to have in spades is common bloody sense. Lots of common sense. Lots of the ability to say, look, that's not what George would have wanted, or no, I don't want to waste time and money on that. I think we should be doing it this way, and so on. So it depends. Your choice of executor depends on your particular situation. Do you have a brother or a sister, or one of each, or a couple of brothers who are good, solid sort of people and got plenty of common sense and would take on the role? Do you have close friends who would take on the role? Would you prefer to have your children? If your children are old enough, it's not much good. You can't appoint your children if they're under 18, and you probably wouldn't even appoint them if they were under probably about 25, because they've got not enough life experience to be able to handle the role. You might appoint one of your children plus perhaps a close friend. You might appoint one child so that he or she can help the rest of the family and more or less translate what's going on with the estate to the rest of the family. But at the same time have somebody else. You might, for example, put one of your eldest child alongside your solicitor or your accountant or your financial planner, somebody that you trust as a professional person. That person might not be a seriously close friend, but they are somebody who understands how these things work, and they can, in conjunction with, say, your eldest child, act in the role. Now we normally, you can have more than one executor, and there's oftentimes quite a reasonable benefit in having two, or even three. After three, things start to get a bit silly, and documents have got to be signed, etc., 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 and it becomes a bit unwieldy. But I think up to three executors is quite doable, provided that they're all more or less around. You don't, let's not choose your brother Bob who lives in Washington. You know, I mean, because all that's going to do is delay documentation and the whole box of dice. But it's not possible to give you a really clear cut definition of who should be executor, except to say you've got to run through your list of people who are potential candidates and tick off the ones that are, you know, more likely than others, and consider the prospect that you'll have more than one.
Okay.
Peter, can I just jump in there? I'm just trying to understand when you're saying having common sense, in that you earlier said that it is the solicitor who basically knows all the procedures and the legal side of things. But does the executor have any decision making? It's the law, it's written.
It
you know,
depends.
what kind of common
Sure.
sense?
Well,
do you mean?
again,
what decisions are they able to make?
Yes. Well, that depends a little bit on what your will says and how old your beneficiaries are. Do you have underage beneficiaries? Have you set up a trust for, say, either your children or your grandchildren? Is there if it is very straightforward, like everything to my spouse and that's it, then yes, the executor's role is fairly limited. But if there's anything that's likely to be ongoing because of the nature of the beneficiaries who might take under the will, then there will be decisions to be made. And of course, the very first decision to be made is which solicitor are you going to go to get this thing done, and is that, you know, and then make sure that person, that the executor chases that solicitor through and make sure that the thing's done effectively, can manage the solicitor and make sure that it's being done at a reasonable cost. The fees in relation to probate are divided into two sections. There's there's the probate application. Now, the way we look after, because we've said, you know, that the deceased person, poor old George, is pushing up his one daisy there, and he's not around to look after his assets. So who's going to look after the assets? The answer is either the executor or the administrator. They are answerable to the Supreme Court in each state. So the Supreme Court issues a document that says to the world, okay, in this case, David is George's executor, and he's entitled to deal with George's assets. That document is called a probate, a grant of probate in New South Wales, where you have a will. If you don't have a will, then it's called letters of administration. But either way, it's a document that makes very clear that who has the power to look after these assets. And in respect of decisions about what will happen with the estate, etc., you obviously want to choose somebody, depending on the complexity of the estate and what is possibly likely to happen, you want to choose somebody who will do what you want. And George has got a question, I think, coming up a little later about what happens if they decide not to. And also to make some decisions that might be discretionary in nature. They won't apply if it's just between the two spouses, but when one spouse is gone, then all of a sudden you don't have a spouse, and your will probably need to change at that point, because now there's going to be some other issues.